Companies Act, Section 466, Dissolution of the Company Law Board and related transitional provisions. Section 466 of the Companies Act, 2013 lays down the legal framework for the dissolution of the Company Law Board, CLB, and the smooth transition of its functions, personnel, and administrative structure to the newly constituted bodies, namely the National Company Law Tribunal, NCLT, and the National Company Law Appellate Tribunal, NCLAT. This section ensures continuity of regulatory operations, protects employment rights of officers, and establishes legal certainty during the transition from the older corporate dispute resolution system to the updated tribunal-based framework. 1. Automatic dissolution of the Company Law Board. Once the NCLT and NCLAT are formally established and become functional, the Company Law Board, which was earlier constituted under the Companies Act, 1956, shall automatically stand dissolved. This shift is intended to modernize the corporate adjudication system by consolidating company law matters under specialized tribunals. 2. Temporary continuity through eligible existing members. Until the NCLT and NCLAT become fully operational, the chairman, vice chairman, and members of the CLB who meet the eligibility criteria for appointment as president chairperson member under the 2013 Act shall continue to function in those corresponding positions within the new tribunal structure. This avoids service gaps and ensures legal matters continue without disruption. 3. Treatment of deputation-based employees. For CLB officers appointed on deputation, they shall become officers or employees of NCLT/NCLAT only if they satisfy the qualifications required under the 2013 Act. If they do not qualify, they will be reverted back to their parent ministry department cadre automatically. This ensures only appropriately qualified personnel carry forward under the reformed system. 4. Rights of permanently employed CLB staff. All officers and employees who were regularly appointed to the CLB will automatically become staff of NCLT or NCLAT will retain the same rights, benefits, and privileges, such as pension, gratuity, and other retirement or welfare entitlements. They will continue in service unless their service conditions are lawfully modified, or their employment is lawfully terminated by the tribunal. 5. No right to compensation for transition-related service termination. Even though the dissolution may lead to changes in employment status, officers or employees cannot claim any compensation under the Companies Act, the Industrial Disputes Act, 1947, or any other law in force. This prevents litigation against the government due to administrative restructuring. 6. Transfer of provident funds and other employee welfare funds. Any provident fund, superannuation fund, welfare fund, or similar employee benefit fund established by the CLB shall automatically transfer and vest with NCLT/NCLAT. Such funds shall be utilized appropriately for the benefit of transferred staff, in the manner prescribed by rules. 7. Vacating of offices by non-eligible personnel. Any CLB chairman, vice chairman, member, officer, or employee who does not meet eligibility criteria must vacate their office immediately upon constitution of NCLT/NCLAT. They are not entitled to claim compensation for the premature termination of their office or service contract. Purpose and significance of Section 466. Ensures a smooth institutional shift from CLB to NCLT/NCLAT. Protects service benefits of eligible employees. Prevents legal disruptions in ongoing company law matters. Enables modern, streamlined corporate dispute resolution. Eliminates redundancy of old regulatory structures. For more details, contact us.